What is the Cook County Residential Landlord-Tenant Ordinance? Well, this is an ordinance that Illinois property investors and property managers should be aware of. To my surprise, I frequently run into investors and managers, and I know some really sharp, really successful, really capable practitioners in this area who've just never heard of this ordinance. Now, some of this is not surprising. The ordinance went into effect in January of 2021. At that time, those of us in the property world were more focused on other issues. We were still fighting the eviction moratorium, both on the state level and the federal level. And this is an ordinance that only affects Cook County, so I think more of the advocacy groups were more focused on the statewide issues and the federal issues. I also think that those who were opposing the Cook County ordinance, they took more of an approach of trying to soften the blow of the ordinance as opposed to trying to defeat it altogether. Now, this ordinance and ordinances like it, they're born of this faulty mentality, this idea that some people have that landlords are exploitative, or if not exploitative, then certainly all the power and all the advantages are on their side. Well, this is certainly not the case. In Illinois, there's a lot of accountability for landlords. There's a lot of ways to punish a slum landlord. I can tell you from 10 plus years experience, there's almost nothing going in the other direction. It's very hard for a landlord to prevent themselves from being harmed by a very bad tenant. Now, that being said, and I could go off on this for quite a long time. Those who know me know that I have quite a few opinions on this matter. My job here, though, is not advocacy. There's plenty of time and appropriate circumstances for advocacy. My job here is to make you aware of this law and to help you minimize the damage you can experience by not complying with this law. The Cook County ordinance, it applies to all of Cook County except for Chicago and Evanston. Chicago and Evanston, of course, have their own notorious statutes in this area. A lot of people know about the Chicago RLTO. I do believe that this particular ordinance was fashioned after the Chicago ordinance. There are some similarities. The biggest thing, the first and biggest thing that comes to mind is the issue of security deposits. In addition to the statewide rules about security deposits, the new Cook County ordinance has all kinds of rules that you're going to want to make yourself aware of. You've got to get a signed receipt from the tenant showing that you've disclosed to them where you've put the security deposit, that it's in an approved financial institution. You want to be very careful about how you go about returning that and how you go about applying certain damages to the security deposit. Some other things that you want to be aware of. There are a lot of new disclosures that are required. Again, very similar to the disclosures that are required in the city. There are certain things that can't be in your lease. One thing that comes to mind, and this is one of the more frustrating aspects of this law for me, one way that I help my landlord clients. At the very beginning of the process, you have to give out preliminary notices, whether it's a 5-day, 10-day, 30-day, demand for possession, whatever. Landlords spend a lot of time trying to play this cat and mouse game, hunting down the delinquent tenants, getting that notice in their hand per the state rules. What you're allowed to do, or what you were allowed to do before this ordinance statewide, was you could adjust your lease to where it said that you could serve the notice by email or posting it on the door as long as the tenant signed a particular provision in the lease and basically waived those obligations. You couldn't do this with the summons. The summons is a whole different story, but at least with the preliminary notice. Well, unfortunately, this ordinance no longer allows landlords to do that waiver in their lease. So you can't waive the notice provisions. You're stuck with what the state requires you to do. This wastes a lot of time, but again, it is what it is. We have to follow the rules as they are. There are rules about utilities, disclosures. There are one thing again, and this is a big disadvantage to landlords if you get into litigation. You can't collect your attorney's fees. You can't even ask for attorney's fees or put in the lease that you're entitled to them in the event that there's litigation. As long as I've been doing this and as much as I'm aware of this ordinance, I always forget that in Cook County there's this judge over in Rolling Meadows. I get in front of him, I'm a judge, we'd like our attorney's fees, and he has to continue to remind me, counsel, you can't get your attorney's fees here in Cook County anymore. I'm like, oh, that's right. So this is a big disadvantage for the landlords. This ordinance, again, as much as I don't like it, it is what it is. We're here to help you navigate this. What I would like my investor clients and my property manager clients to know, not only are we happy to represent you, we're happy to provide education on this important issue. I wouldn't go it alone on this. As busy as I am, I'm always happy to try to make time for seminars, for realtor group meetings. This is not something you want to go alone. We're happy to help you on this, and I want to thank you for your time today listening to this video.